Some of you might remember that former Prime Minister Paul Keating once said that if you walk into any pet shop in Australia, the resident galah will be talking about microeconomic reform. And the same might be said of evidence-based policy. Governments swear allegiance to it, but the principle is, well, used to be at least, more often honoured in the breach than in the observance. So today we're very fortunate to have two people who are leading experts on not only evidence-based policy, but more importantly from our perspective, how to actually implement evidence-based policy. Peter Neyroud on my left is a lecturer in evidence-based policing at the Jerry Lee Centre for Experimental Criminology at the Institute of Criminology in the University of Cambridge. He's currently co-chair of the Campbell Collaboration Crime and Justice Coordinating Group and holds appointments at a number of British universities. I won't list them all, there are far too many of them, Peter. In 2004, he was awarded the Queen's Police Medal, and in 2011, he was awarded a CBE in the Queen's Birthday Honours List. With more than 30 years policing experience behind him, he is without doubt one of the world's leading experts on evidence-based policing. So Peter, as I understand it, will be talking to us about introducing an evidence-based approach to offender diversion in the criminal justice system. It also gives me great pleasure to introduce Dr. Robin Milden. Robin has a background in educational psychology, but her career focus has been on the translation or conversion of social research into public policy. She's worked with a number of government and non-government agencies in a number of countries as well to achieve that outcome in both health and in human services. She's the founding executive director of the Centre for Evidence and Implementation and founding co-chair of the Knowledge Translation and Implementation Group with the Campbell Collaboration. So I think the plan is that Robin will respond to Peter's address and perhaps help anchor Peter's remarks in an Australian context. So ladies and gentlemen, could we begin by giving our two speakers a warm welcome to Australia. So Peter, the floor is yours for 45 minutes.
Well, it's a pleasure to be here. It's a long way to come, and this is en route to Hong Kong, where I'm teaching some of my students evidence-based policing. It is a worldwide movement. I'm hoping that my bags might actually arrive and follow me, since Qantas managed a piece of non-evidence-based baggage arrival. Okay, so what I'm going to talk about is I'm going to start with the Campbell Collaboration's approach to evidence, and just a little bit of explanation about where we've got to on that. And I'm going to do the second half on a big randomised control trial that we've completed from Cambridge in Birmingham, which is about how to put diversion, and in particular diverting offenders that you might otherwise have prosecuted into diversion rather than into the court process. And this kind of extraordinary conundrum that we've got at the moment, just about worldwide, and certainly in the developing country, where we had a big crime rise in the 80s and the early 90s, and then we've had a long crime drop, and this is not the place to have the debate about why that may or may not have happened. The fact is, it has happened, and yet our prisons, wherever we are bulging with prisoners, and we don't seem able to try and to resolve that issue. And using evidence isn't a straightforward process, but it does seem to me to be one way to open those doors, and above all to stop people going in there in the first place. So just hold with me on the journey. So that's the overall piece. Start with the systematic reviews, work through to the evidence on diversion. Oh, and by the way, in the midst of that, which is why this is particularly timely, I raised the point about diversion in the UK, and saying, you know, we really ought to use evidence only to be asked, well, perhaps you'd just like to write that review for us. So I'm also going to talk a little bit about the review that I've done on the overall evidence for diversion and what might or might not work. So that will come into it. And as Don said in the introduction, sorry, this is a bit indulgent to put two pictures of yourself up early in the lecture, but it's kind of to make the point that I am very much a pracademic in that sense. You'll notice me proudly displaying the PhD on the first slide, because actually that only happened last week. I've finally completed the damn thing. So on the route to respectability. But the 30 years in policing, but particularly in the last 5 years of my career when I was running the National Policing Improvement Agency, my job was evidence-based policing for the United Kingdom. And the current College of Policing in the UK was basically my creation as well, an evidence-based policing professional body for policing. And this is a long process to get that to move. And meanwhile, I now have just slightly over 200 master students from policing across the world, including Australia, who are also getting evidence-based policing and applied policing as part of their programme. So I'm still at it. And clearly, developing the evidence is very much part of the Campbell Collaboration. So if there's one thing I would like out of this event, I would like everybody here to visit the website. Okay, there is, particularly if you're in this field, for me, if you were going to start thinking about evidence-based policy and change in criminal justice, a good place to start is with the meta-analyses that have been done. If for no other reason, and most of the ones on policing, or many of the ones on policing, were the ones that I commissioned when I was running the National Policing Improvement Agency, because it seemed to me fairly obvious that the starting point is to know what you know, and to know it in a form with a degree of consistency that allows you to build forward. So I commissioned 12 systematic reviews on policing in areas like hotspot policing and problem solving, and things like how to manage stress, occupational stress in policing, on the basis these were key topics that we needed to know what we knew. And a great way to do that is to go and systematically search. And that's very, very different, for those that are not familiar with this, very different from getting someone to write a literature review. This is about systematically searching for the best evidence and systematically determining what the evidence is and the outcomes are. I put some UK stories about the prison population up. They are, having searched through the Australian press, pretty similar to the stories that you're seeing. I mean, you've had one or two ministers. I found an absolutely fantastic quote from, is it Mr. Foley, I think, gave an absolutely fantastic quote about his approach to penal policy, which seemed to me to be slightly to the right of Attila the Hun.
This is the Rackham, Packham,
Rackham, yeah, that one. But I avoided the temptation to put up a load of Australian ones on the basis that Robin was going to give you the context anyway. But to be honest, yeah, exactly. So, and you know, it's one of the benefits of being from outside. And by the way, I'm Swiss, not British, so I can be really neutral. Okay. Even on the subject of rugby, for those that. I just thought I'd mention it and drop it in. Okay. Well, I shan't mention the cricket. Right, let's move swiftly on. So the context in the UK is there's just an increasing group of people from across the spectrum, whether it be the politicians. I mean, I've got there quoted two ministers of justice or Lord Chancellors, two of the key politicians, both saying we need to reduce the prison population. You've got judges, the Lord Chief Justice saying we need to reduce the prison population. And what's happening to the prison population in the UK? It's going up. And you think, well, why on earth would that be? And part of the problem is, where on earth do you start to tackle it? It's difficult to convince judges to do more community sentences, because they don't actually have much confidence in the way in which community sentences are managed. It's difficult to get politicians to change the law, because what politicians do is just create more of it, and with more sentences and more things to be done. And after all, there are developing areas of crime, such as internet child abuse, areas like that, where there is a tendency to want to incarcerate anyone who does that, because it is, they're terrible things to do. And you've got a lot of middle-aged men who are viewing images, possibly their first conviction, and they're going to prison. Certainly are in the UK. I mean, the National Crime Agency reckoned that there are around 50,000 males viewing indecent images of children. Well, those are all imprisonable offences, and you kind of start again on the next track of imprisonment. So, as part of our kind of drive to try and inform in this territory. The other thing that we as the Campbell Collaboration have done in the last week, because it only got posted on Monday last week, was to say, well, we've got a lot of individual systematic reviews on areas of corrections and sentencing. It would be quite nice if we could just summarise them, so that particularly for the benefit of for those working in politics, 2 pages. It's got a handy length, and it summarises. Might be a bit too long for 1 or 2, actually. I think Donald has some difficulty with more than 140 characters. But we've summarised it. I would recommend this. I would commend it as something to use with those that you want to inform. I think it's a pretty good summary of the evidence as we know it from the systematic reviews. You're talking of over 500 high-quality studies that are informing this review, so it's a pretty weighty body of evidence, and I think it's quite informative. And just to pick out the kind of the highlights, it's broadly speaking encouraging us to use alternatives to prison, and it's picking up the potential for treatments, and it's above all picking up the potential for diversion. And if you were setting out on an evidence-based approach to crime and sentencing policy, I think this would be a pretty good place to start. And it's based on a series of reviews, and just to pick out 1 or 2, the Scared Straight one has been around for a little while. We haven't updated it because, frankly, the evidence is so incontrovertible that taking kids to prison to persuade them that that's why they might end up in this terrible place, it turns out to be a terribly bad way of making them worse. I noticed that Attorney General Sessions in the United States is a huge advocate of Scared Straight, which I think should encourage all of us not to be. And the juvenile curfews. A lot of countries have invested in juvenile curfews, primarily based on a deterrent approach to young people. They don't work either. You're beginning to get the drift that deterrent-based approaches that appear to have a kind of common sense or intuitive feel to them don't intuitively, well, when you can't actually test them properly, produce the result you might expect. This particular review, I had the pleasure of presenting to the then Justice Secretary Michael Gove in the United Kingdom, to be greeted with a rather dusty look, because it wasn't entirely consistent with government policy. But the effects of custodial versus non-custodial sanctions, it's quite clear that particularly if you're talking about the comparison between short-term prison sentences, and I think both of our regimes suffer from a lot of short-term prison sentences, versus a community sentence, you are basically throwing money away and making lives worse by investing in the former rather than the latter. Community sentences, on the whole, work significantly better for considerably less dollars. I nearly said pounds, but dollars. I definitely don't say pounds these days because they're not worth very much. But more particularly for my purposes today, we have, for some while, this is a 2010 review, formal processing of juveniles in the criminal justice system. We have known for some time from the systematic reviews that formally processing kids, and by the way, I think this certainly applies to young adults in transition to adulthood, so up to say 25, and I think the evidence is reasonably clear that it also applies to adults entering the criminal justice system for the first time as well, that formal processing does more harm than good. And is to be avoided, and it's a pretty, Anthony Petrosino and his fellow authors were pretty clear. Based on the evidence presented in the report, juvenile system processing appears to not to have a crime control effect, and across all measures, and that was everything from frequency to prevalence to harm, appears to increase delinquency. So why on earth would you invest in formal processing of young people on the basis of that? I could stop there if you want, but. And even in the land of incarceration, that the truth is dawning. Interestingly, there's a headline in the American papers today, which is a survey done by the American Civil Liberties Union, that even Trump voters support a reduction in the carceral state in the States. Just let that one lie. But there's a growing and significant number of studies in the States, and the three states mentioned here in particular, that reducing the prison population does not have the counterbalancing effect of increasing crime. We're not, most of us in the field are not at all surprised by that. Whereas formally processing, as our briefing paper says, almost certainly does have the impact of increasing crime. And the opportunity therefore lies in trying to take forward an approach to diversion, which is creative and pushing those boundaries. And the sort of the questions that lie in the room here is, where is that boundary? Where is the boundary where diversion is effective and warranted? And how do you determine that boundary? Is it on the basis that solely of the effectiveness of crime control? Is it on the basis of the views of victims? Because victims need to feel that something is being done about their crime, and they need to feel confidence in the criminal justice system. Or is it simply on the basis of cash? What's the right balance between this? And where does it lie? Do we divert? Are we safe to divert all offenders? Do we just divert low level offenders with low level crimes, or are we prepared to push the boundary a little bit? And furthermore, how do we want to push the boundary? What sort of things are we talking about when we divert? Are we talking simply about sitting down, as we used to do and when I was a police inspector in the UK, you'd sit down with an offender, you'd give them a thoughtful and creative piece of your mind for about 15 to 20 minutes, and then they'd be released. That was our approach to cautioning, which obviously varied from person to person in those terms. I'm not sure that my talks were particularly effective, but at least they were out of the police station and they weren't formally processed. And the Criminal Justice Centre in the States came up with, I think, quite a good set of ideas in that sense back in 2009. So, and I quite like the phrase "safely divert," which means that I think there is an onus on us to be clear about what safely might mean in that mean. It certainly means safely for the victim. It means safely for the rest of society, but it also means safely for the offender as well. So finding a way to divert in the right way. It says identify the offender characteristics that fit a strategy. That could be risk, it could be the things that need to be treated, it could certainly be things like mental health problems and reduced recidivism. And it says there propose a common system-wide risk assessment instrument. That's a tricky one because I think we could debate the risk assessment instruments that you might use in these cases quite a lot. We're in the process of developing one in Durham with Durham Police, which is designed to triage offenders into broad categories of low, medium and high risk, on the basis that gives you, certainly for the low risk, a pretty irrebuttable presumption that you're going to take them out of the system before they enter it. But that's still in the early stages of development at the moment, and it's not straightforward. I think there are bound to be some concerns about any algorithmic risk assessment process and the potential prejudicial effect of it, because inevitably it tends to be based on past background, which tends to be quite a decent predictor of future, but that also therefore interacts with whatever the police do in a particular area, and therefore you can end up back in the same place. So let's just come to the UK context just for a few minutes, because it's an interesting context, and this kind of is a almost sort of case study of how you might or might not go about the issue. So we had a Justice Secretary 3 back. We've been going through Justice Secretaries quite quickly. We don't have the world's most stable government at the moment. Might be slightly more stable than Zimbabwe, but it's not doing very well. And the Justice Secretary 3 back was very interested in a rather more penal approach to diversion, so he launched a consultation about diversion. He was also keen on simplifying things. So let me give you his approach. So we have over 40 or 50 years built up a rather complicated approach to diversion. On the left-hand side there, you'll see the seven potential disposals. You could have a caution, you could have an informal warning, which is slightly less than a caution. You could have a community resolution, which looks like an informal warning, although it's supposed to involve something to do with a community. You could have a cannabis warning or a cat warning. I don't know why we singled out cat specifically for another low-level drug in inverted commas for that particular approach, but we did. You could have a fixed penalty notice for disorder, or you could have a conditional caution. The problem is we don't have a precise way of determining which one of those you get. So it varies where you go as to what you get. But we got to the point just prior to the Justice Secretary launching this particular simplification, where we had about 38% of our entire criminal justice disposals were going into one or other of these boxes. Okay, 38%, which is quite a lot in those terms. It has dropped. Soon as the Justice Secretary launched this consultation, he also launched various attempts to try and crack down on forces using cautioning, and it's dropped to about 24%, which inevitably means we're now prosecuting more people in the process. But nevertheless, the simplified system then got put into a pilot, and the pilot results should have been published, but they haven't quite yet. Not the least of which, because they produced one or two inconvenient truths, and that was that the minister's ideas turned out to have a negative cost-benefit. Well, as they say in policing, shit happens. And as we got to the point of the results of this process coming out, the National Police Chiefs Council, which is the group of all the chiefs in the UK, did something sort of slightly novel. They suddenly said, so where's the evidence? Is there any evidence for the approach that the ministry wants to adopt? Because particularly if we were thinking about going into something for which there is a negative cost benefit, we really want to see the evidence for going down that track. So they commissioned a review. And as I've mentioned, it was handed to me. I think it's something deeply ironic about the National Police Chiefs Council commissioning review, and then finally they get one of their own to do it in the end. But in some ways that is an advantage, because having spent a lot of time, and indeed for a period of time I was the National Police Chief's lead on out-of-court disposals and diversion, and was responsible for the creation of one of those seven strands at a time before my full induction in the Hall of Fame for evidence-based policing had been complete, and actually it was a terrible and lamentable failure. And I'm happy to confess, because confession is good for the soul. So let me just dwell a little bit on a non-evidence-based failure. So I suggested back in 2001, 2002, in midst of the height of the Blair Labour government, that we ought to have a conditional caution as a means of keeping people, not just juveniles, out of the court system. And what we would do is that we would take offenders who we were thinking of prosecuting, and where they had admitted the offence, and we would get the police officers to devise conditions, and that those conditions would be used to keep them out of custody as long as they completed the conditions. I thought that was quite a good, imaginative approach. So a number of things happened. The first of which was that in the course of the negotiation about it, and just before we launched it, our system is that the police usually have discretion to do disposals, but in this particular case, because it was a new one, and we had the Crown Prosecution Service round the table, the Crown Prosecution Service decided that it should only be the only approval, because this was an alternative prosecution, which is something that they had control of, should be with the prosecutor's approval. Anyone beginning to see where this is going? So the prosecutors are then demanding that a full file of evidence is prepared for every conditional caution. And if there's one thing we know about police officers, we will run as far as we possibly can rather than fulfill a full file of evidence, okay? So you give us that option, full file of evidence, and by the way, to prosecute, it's a small file of evidence. Okay, so what happened 10 years later? Around about 0.2% of all disposals were conditional cautions, and the only conditional cautions that were being given were for minor criminal damage, where somebody was prepared to make an apology and pay a small sum of money to the victim. Okay, so it was a complete, abject failure. Still, as I say, confession's good for the soul. So if you're going to write a brief on evidence-based policing, well, on evidence-based diversion, where do you start? We tend, particularly in Campbell, we tend to gravitate towards looking for the best evidence certainly for what works. We look for the best evidence within randomised trials on the basis that at least with a randomised trial, if it's been done properly, you should have a clear idea on the cause and effect. And we certainly wouldn't be going down to pre and post studies, so you'd be tending to look in that territory. As it happens, diversion is replete with studies. My PhD was on RCT. So the first thing on RCTs in policing. So the first thing that I did as part of that was to find them all, which I was slightly surprised that nobody had done. And then after I tried to find them all, I wasn't at all surprised why nobody had done it, because it's quite difficult. But actually, in doing so, I found that there were a very significant number of diversion studies. Critically, a mixture. So most of the ones that are not well known are not well known for the very good reason that they failed. And they failed because actually implementing diversion is quite tricky. It's quite tricky because there are a series of things, which I'll come on to, which you really have to pay attention to. Not the least of which, the point of eligibility screening. Who are you going to put into diversion? Let alone what conditions or what process are you going to use, and are you going to track that so that so what happens is what you're intending to happen. Are you going to do that properly or not? All of those proved to be quite tricky in the trials that I reviewed, and about, as I think I'll show you in a minute, about half of the trials I would regard as a complete failure to achieve the objective, more than an effective trial. But there is a group which I'll come on to. There is a group which most definitely did succeed and have demonstrated quite significant promise. One of the critical reasons why we wouldn't, of course, look at just one trial is perfectly illustrated by this little case study. So, Bodyworn video. It's the latest craze in policing. I think there's a number of Australian police forces are investing in it and getting Bodyworn video at the moment. A lot of American police forces, particularly after the Obama President's Commission, have invested in Bodyworn video, and almost every police force in the United Kingdom now has Bodyworn video. So the aim of the exercise being to reduce complaints, to reduce assaults by officers, and to increase the level of evidence gathering, particularly in public order situations or in domestic violence cases. This particular trial was the latest one to be published, and just because it was Washington DC, it got a lot of publicity, not just in the United States. It got a lot of publicity, full stop. And it was a trial that suggested that Bodyworn video had no effect. A fairly quick read of the trial itself demonstrated that it was hardly a surprise, because what had actually happened in the trial is that the randomisation process involved them randomising on the basis of individual officers. Anyone knows, who's involved in policing knows, that if you randomly assign every officer in the division, given that the propensity of police to send multiple units to any given incident, about 60 to 70% of all incidents are going to therefore have a body-worn camera present. And therefore the cross-contamination in the trial meant that it was most unlikely there was going to be any effect whatsoever. Surprise, surprise, there wasn't. So you don't look at one trial, particularly when you've got 30 RCTs out there on body-worn video now from across the world, including Australia. You've got 30 RCTs out there. You wouldn't look at one trial, and you particularly wouldn't look at one trial when there is a significant problem with bias in the trial, which is why you do systematic reviews, because you want to find the best trials, the ones with a low level of bias, and you want to be able to look at the results in aggregate, not in individual. And in the case of diversion, we've now got the benefit of 2 systematic reviews, not just one. So we've got one which asked the all-important question, does formal processing reduce crime or not? And the other one asked it from the other side, which is, does police-initiated diversion managed by the police reduce crime or not? And that one is about to come out, so it's in review at the moment. It's been conducted by David Wilson and colleagues from George Mason University and a colleague from Hull University in the UK. It's using mostly UK and US, but also some Australian work as well. And broadly speaking, it has, just as the Petrosino one saying formal processing doesn't work, the Wilson and others trials looking at the effect of police-initiated diversion says that police-initiated diversion does work. And it does reduce crime. So either which way you look at this question, and in particular if you look at the question, which is critical, if you look at the question as to whether if the police deal with this before it ever gets anywhere near the court, which is critical to both the cost in the system, because as soon as you send anything to court, you light all sorts of cost lights, okay? And keeping it out of the court system, whilst at the same time having some significant level of accountability on the police to do it properly, seems a pretty good place to go. Quite often, as a Campbell Collaboration, we get criticised for only focusing on the RCTs. And for me, the very best systematic reviews are systematic reviews that start by doing that side of the piece properly. So they look for the best studies, whether they be RCTs or quasi-experiments or high-quality controlled design studies, and then they look for the totality of the evidence, and in particular the qualitative evidence, to interpret that in an effective way. And on diversion, we've got so much qualitative evidence out there. I'll just summarise some of the UK stuff, but I've had a look at quite a number of Australian studies as well. There are very similar lessons coming out. Speed matters, so doing things quickly matters. We know, and it doesn't matter which one of our court systems you go to, if you compare the speed of doing a caution or diversion with the speed of doing something in court, there is just no comparison. We are talking, and particularly if you're talking about a youngster, I have 4 children. I certainly remember them as, all of them as teenagers. One is still a teenager, very much so. But you know, their ability, a bit like a chief constable, their ability to remember something is along the lines of a goldfish. The memory doesn't last very long. And if you're talking about a court process, which when we look at the Operation Turning Point trial I'm about to talk about, takes anything up to 6 months to resolve a case, that is a huge part of a young person's life taken up. Whereas if you're doing it with something within 48 hours, it's a completely different effect. The teachable moment here is arrest, not punishment. So I'm going to now just turn to Operation Turning Point, which is, Turning Point is a big trial, so it took us quite a while to do it. It was based in Birmingham, across the whole of Birmingham in the UK, and just to put that in context, Birmingham's the second largest city. 1.1 million people live in the city of Birmingham as opposed to the conurbation around it. So we're talking about a trial in a pretty large area, and it's a pretty, the bit of Birmingham where most of the cases came from is is a tough area. So we deliberately did not go to a small rural force or to easy places to do it. We went to a difficult place to do this. And it was not an easy trial to conduct. So let me just talk you through it. So what we were trying to test was this boundary of diversion. The normal thing when most of the tests of diversion have taken people frankly at the level that you would expect diversion to happen. So quite low level offences, minor shopliftings, those type, that type of offence. We wanted to take offenders early on in their career, so with either one or no more than one conviction. We would want to take any offender for whom our court sentencing guidelines suggested that they wouldn't automatically get a prison sentence on first appearance without any prior conviction. That's quite a high bar, actually. That means that you're talking about quite, to go to prison in the UK on first appearance without any prior conviction, you're talking about quite a serious assault, a street robbery with violence, a significant burglary of a house, that type of offence. So anything below that threshold is in play. Plus we took out any offences where they had already been cautioned. So we're only talking about offenders the police had decided the public interest and the evidence test suggested should be prosecuted. The other thing we took out, incidentally, was we took out the requirement to admit the offence. If you are talking about communities who do not have a high level of confidence in the police, and you have that problem here in Australia, I know, then they are much less likely to want to cooperate at an early stage and admit offences. Therefore, they are much more likely to enter the system earlier and end up escalating more quickly into the system. David Lammy, a North London MP, has just done a big report in the UK on disproportionality in the criminal justice system, which I suspect will have resonance in Australia in a different form. And he very clearly identified the turning point approach, which is don't require admission, as being an absolutely critical way of rebalancing the system at the early stages. So we've combined deterrence and desistance. The requirement is that you do not reoffend, and that you're under a 4-month contract not to reoffend. That we give you support, which arises from a conversation that you have, in this case with a police officer, but there's room to, and we've tested in another force, using a probation-trained navigator at that stage as well. But this particular model in Birmingham was using a police officer. And that you get no prosecution in return for compliance. That's the end of the matter. No criminal record. And we do know, there's plenty of research now, in certainly across all the Anglo-Saxon jurisdictions, that the impact further down the track of getting a criminal conviction is very significant in terms of your long-term life chances. After all, we spend a lot of our time vetting people for jobs, vetting people for things. I mean, you simply cut out a whole range of occupations if you get a criminal conviction early in your life. But treatment in this case is a deferred prosecution rather than a caution, and as I say, for low-risk offenders. And the sample in Turning Point was offenders that the police would decided to prosecute, not more than one conviction, not going to prison on that first case. We took out a range of types of offence. So a serious sexual offence, for obvious reasons, was out. Terrorism, we thought, was probably out. Although, interestingly, I think this type of approach might be very pertinent for people who are involved at an early stage of de-radicalisation. I think there is a potential for using it in those terms. I certainly think we're currently testing, in the early stages of testing, things like, for example, using this for hacking offences in cybercrime, which are frequently young men, and 15, 16-year-old young men, quite often on the autistic spectrum. So taking people out of the system at an early stage and giving them an opportunity to go straight seems quite an important way of going about things. So we had 414 offenders in the final sample, and we measured whom we randomly assigned. So what happened was that as they came into custody, once the decision had been taken that they should be prosecuted, and the custody officers did an eligibility screen and then pressed a button, and they were either assigned to prosecution or they were assigned to Turning Point. They then came, they then had, within 48 hours, they met a police offender manager who had a cognitive-based interview with them about their offending. And just to make a point, almost all of the offenders from we deliberately didn't sit in on those interviews, but from talking to the offender managers as part of the research, it was quite clear that the vast majority of offenders, even those, well, perhaps most particularly those who hadn't actually admitted the offence in custody, basically had a lot to talk about when they had the conversation. And one of the comments that came back was how unusual it was in the criminal justice system for the offender to be given a voice to talk about their offending, and particularly at that early stage. So participation was voluntary. I appreciate you could argue that's a slightly conditional voluntary. You're in custody, you're being offered the opportunity not to be prosecuted. It's pretty conditional, but you know, you got yourself into that position, so you've now got an opportunity to get yourself out, would be my, perhaps that's a slightly police officer's view of life, but nevertheless. We didn't, incidentally, they did have access to a defence counsel if they wanted it, and quite a number of them took up the opportunity for the phone call with a defence solicitor. Not one single defence solicitor advised their client to do anything other than take the turning point condition. Okay. And interestingly, the only legal complaint we had through the trial was one defence solicitor eventually, which I think is quite a credit to the trial, decided to go to the High Court to try to claim that the conditions in Turning Point were more severe than prosecuting and were disproportionate. Okay, we thought that was a pretty good advert for Turning Point, to be frank. It was certainly one I used with the Justice Secretary. You know, if the Defence Counsel thinks that what we're doing is a bit too tough, it kind of says it all, really, and it certainly makes the case that it's not a weak and easy option. Those are the headlines. You are taking offenders that you would otherwise have prosecuted, and you're taking them out of the court system, and you're giving them a set of conditions, and not all of those conditions were perfect. They were imperfect, but they were more. We did put a lot of effort into getting the conditions to work through the trial. 34% reduction in crime harm. I'll come on to how we measured that. There were more offenders in the Turning Point trial who actually had a justice outcome in terms of having a penalty imposed than there were in the court, significantly, and it reduced cost by 45%. You're the Justice Secretary. What do you want to do? On the whole, I tend to think Justice Secretaries look at the bottom one first. But I'm frankly, if it had just been a score draw, if it had been the same amount of crime, and if you take the normal measures of crime, incidentally, which is prevalence and frequency, it was, I think we were 11% down on one and 9% down on the other, so which is just at the margins of significance, but not quite. But the crime harm figure was very significant. And so reduced harm, along with my co-authors, Larry Sherman and my daughter, Eleanor, we're responsible for a thing called the Cambridge Crime Harm Index. And what we've been doing is making the case that we spend far too much time in the criminal justice system worrying about individual events and not enough about the harm, the relative harm. And what we need is a weighting of the individual events, so we differentiate better between the more serious ones and the ones that are low level and volume. So we've taken the entire corpus of UK offences, and if you want to see the Cambridge Crime Harm Index, look on the Cambridge Institute website, and it's a button on the right-hand side of the Cambridge Institute website. You'll find the Cambridge Crime Harm Index, or you can find it in the article in the Oxford Journal of Policing. And we've weighted every offence by taking the starting point within the UK sentencing guidelines for that offence and using that as a weighting measure for each individual offence. And the reason for the starting point is we want to take offences without any of the offender's involvement in the offence. So the starting point is before you add aggravating and mitigating factors, and you're comparing all offences on a level basis. One of my students has actually created a crime harm index for Western Australia, and we're similarly supporting the same work in Queensland Happy to do the same process for New South Wales. It's relatively straightforward and easy to do. And just to put the facts on it, we calculate crime harm in terms of the number of prison days that would have happened. So, for example, for murder in the UK, it's 5,891 days is the minimum threshold. It's 15 years. 15 years imprisonment is the minimum starting point on first conviction for homicide. And likewise, you go back down to, say, shoplifting is 0.5. It's usually a fine, so we calculate fines on the basis of how many hours does it take you to earn that fine with a minimum wage. It's a relatively simple process. And just to set out the approach, you know, the Home Office only just moved from demanding prevalence only to frequency, and we've now managed to encourage not just the Home Office but our own Office for National Statistics to adopt a severity index as part of the national statistics. So we're pushing to try and get this approach where a focus on harm allows you to try and take quite a lot out of the system if you're careful. Increased justice. We tracked through all the cases from both sides. Virtually everybody in the Turning Point trial, every single offender was held to account. They had their contract, they had their conditions, and they either complied or they were breached. That was not the case for the court side. In the court side, partly because of the pressure of cash on the Crown Prosecution Service, a significant number of offences just basically the prosecutions petered out. Sometimes after 6 to 9 months, petered out. Not always for for reasons that there was no evidence. Just simply they'd had 15, 16 appearances, and the CPS decided there was no public interest in carrying on. Slightly depressing, actually. Very good, very important question that was raised very early on in this is fine. It's good for, it was beginning to be clear that it was cost effective. It was beginning to be clear that it reduced crime and crime harm. But the officers wanted to know whether what it was doing for the victim. So we decided to have a second randomised control trial, and of course look through the whole corpus of evidence, and we could find no other examples worldwide where anybody had randomly assigned the victims to see what the victims felt about diversion or prosecution. Anyone like to guess? So the first thing is, it's quite important to know what the offenders got if you put them in the prosecution process. And the answer to that is, and we tried very hard not to instruct officers to give them a kind of gloomy prediction about what the court was going to do. But when you look at what actually happened, so they got fines and conditional discharges. It's perhaps not surprising that the solicitor took the case to say that our approach was somewhat tougher, because the offenders in the Turning Point sample were getting a mixture of restorative justice. They were getting a requirement to attend treatment if they had alcohol or drugs problems, requirements to attend employment agencies if work and employment seemed to be an issue. We provided housing support. We also provided mental health support, and also there were requirements to do unpaid work as well. So it's quite a significant spread of conditions. What became very apparent was the number one thing, and if you look at the literature on victims, it's pretty apparent actually, the number one thing the victims wanted to know was, were the police, if they were going to do this approach, making a credible effort to try and stop it happening again? Because if they were prepared to go with it. And that of course required that there should be some clarity about the explanation. I don't know what the situation is in Australia, but if your case goes to court, you get absolutely no feedback about why the decision was made to take a particular approach or not. Certainly in the UK, you get absolutely no feedback. And indeed, when we asked the magistrates, is there a possibility that you could explain to victims why you made the decision? They said, no, it's a judicial decision. We don't respond to queries. And you think, well, yeah, but... So we took significant portion of our victims. We had pretty high response rate from those victims. And we put a lot of effort into, a lot of effort, a significant amount of effort with the police officers into getting them to explain things in a structured way. So we use the scripts out of restorative justice, and it's obviously an important part of the system that you don't just do something, that you use the evidence from restorative justice to do something better. And in this case, it's a structured explanation, a structured approach to both being empathetic, but also being very clear about what you were trying to achieve and why you were trying to achieve it. Victims whose cases had gone to court, about half of those were satisfied. Victims whose cases had gone through turning point, nearly 3/4 were satisfied. I've been involved in the criminal justice system for, I'd say, nearly 40 years. I think it is nearly 40 years, actually. And I have not seen anything that differentiates to that extent between with victim satisfaction. And critically, they were more likely to think that it wouldn't happen again. The other thing we did incidentally was to ask those whose cases had gone to court whether they would have liked their case to have gone to court or turning point, and that figure was even higher. It was over 80% said they would much rather their case have been dealt with by turning point than going to court. That may just have been the fact that they hadn't actually even got any feedback from the court as to what their case had actually received, but nevertheless, they were significantly happier. It did matter whether, and sorry, this slide was, if the slide, on the left is the court case, on the middle is the turning point sample, and on the right-hand side is if we'd just done turning point without doing the structured explanation, it would still have been a little bit better. But doing the explaining what you're doing that properly makes a big difference. Okay, it's as good as court without the explanation, but it's a hell of a lot better if you do it professionally and you do the work. And it costs less, a lot less. So if we pack that together with the systematic reviews and with the RCTs that are out there, and we take turning point, and there's a number of other trials. There's another RCT that we've just published on diverting offenders in domestic violence cases, which usually causes a kind of slight sucking of the teeth. Okay. By the way, that resulted in a significant reduction in crime harm as well. Low harm domestic violence offenders into a turning point style approach. That appears to work. And work both for the victim and for the offender as well, by the way. If we take that together, those were my conclusions from what's out there in terms of evidence, that out-to-court disposals, whether with conditions or without, are effective compared to court prosecution at reducing harm and reoffending and sustaining victim confidence and satisfaction. And this finding applies to young offenders, young adults, and adults. There were a couple of questions within that which were really difficult to answer from the evidence. Well, like, for example, I can't answer from the evidence whether it's a good idea to create separate conditions for women or not. Although if we look at the conditions in Turning Point, there was inevitably a difference in the type of offences that were being committed, and therefore the types of conditions that were being proposed were slightly different. But there have not been enough tests specifically looking at whether to have different conditions for women and men. The primary focus, because this just happens to be where the tests have been, is on taking low harm offenders with low level offences. And that's I think pretty incontrovertibly effective. We're currently testing taking medium risk offenders through something similar to Turning Point in Durham, and it doesn't look as if, let's put it in positive, it looks as if that works as well. So the question of where the threshold lies may lie more in terms of the public interest and public acceptability than it may lie in the current approaches. this is a slightly more difficult one to be clear about, but because it relies on you doing the conditions properly. But diverting with conditions appears to be good at reducing harm, including domestic violence. The one caveat on that is I think a lot of the trials that have used conditions, the conditions have not been particularly well done and particularly well tailored. And the final thing, which is very much a lead into the world of implementation, is that it really matters that you don't just say, well, of course, diversion works. You focus on why it works and how you get the best outcomes and results out of it. And there's certainly out of the RCTs and the systematic reviews, it's absolutely clear that you have to get the eligibility screening right. It has to be done consistently, not the least of which, this is the justice system, it ought to be fair. And therefore, that process ought to be pretty strong at the front end. Eligibility screening is not just an implementation issue, it's a fairness and equity issue as well. The needs assessment to tailor the conditions has got to be done effectively. And police officers on the whole are not trained in doing needs assessment for offenders, but they can be trained to do it, and they're actually not bad at it once trained to do it. They certainly were pretty good at it in Turning Point. And you've got to focus on tracking. What tends to happen in these situations is that we tend to assume something's happening, and the lessons of implementation in this territory is unless you actively go and ensure that it is, it may not be, and never make assumptions. But given all of that, if we set out our stall to divert more offenders from the system, to do it and be bold about where that boundary lies, and to develop and use the lessons of implementation, we could keep a lot more offenders out of the system before they get in it. We could reduce the impact of the system on low harm, low level offenders, and increase the potential to focus more of our efforts on those that have got more complex, more difficult problems, and therefore potentially keep them out of custody as well. And it seems to me diversion is a really important place to start. Start at the start of the system. Don't start when it's so late that people have got multiple convictions. Thank you.
Thank you very much. Very much appreciate that.
Thanks, Peter. Do I have to turn this thing on? Okay. It's good you're filming me because it keeps me a little under control. And I'm a little annoyed at you because you should feel as jet lagged as I do right now, and you were good. And I was hoping to go, gosh, he was shocking, made no sense, right? It's because we're both jet lagged, which means it takes the pressure off me. But you didn't do that, Peter. Let me down. It's good drugs. Apparently. Well, you do have connections. All right, firstly, I want to acknowledge the traditional owners of the land that we are meeting on today, elders past and present, and any Aboriginal and Torres Strait Islanders that might be in the room with us right now. I also want to say that since sort of assisting setting Peter's week up, I've never had so many calls from police since I was a teenager, right? And every time I got a call, I get like constable, they all have extremely deep voices. I don't know what that's about. And they were all men. I had no females ring me. What's going on there? And then I would panic every time they left a message. So I'd find myself in this kind of weird adolescent space where I'd ring them and go, "Hi, it's Robin." Hoping it was always much more interested in him, but I've never spoken to so many police. There's quite a few coming to your lecture in Melbourne. I do want to make some comments, but then as Peter was talking, like anything, I sort of slightly changed my mind and did want to present a few slides just to get at the implementation point. So I'll say a few things and then we want to open it up to the floor and hope that you guys have a few questions or a few comments, try and get some interaction going, and then everybody can go. Centre for Evidence and Implementation, for those of you that don't know, we're a new not-for-profit, what we call intermediary agency. That is, we work between research, policy and practice to either help policy and practice select evidence or what works to inform decision making. We don't exactly say what to do, but we will provide a raft of information to help ensure that both policy and practice can make a decision informed on some evidence. We also work pretty hard to then support that evidence to be implemented. So there's a lot of stuff on shelves. So how many people have gone to training of, I don't know, some effective approaches, or done a policy brief on effective approaches that is still sitting on your shelf that you never looked at again or did? You can say. Camera's not on you. Marg, she's on my team. She's not allowed to say that. Put your hand down. Or at least experience that, right? So particularly in the fields of child welfare, human services that CI and the main works in, there is a lot of stuff that people are going to that we are hoping the system implements that often doesn't get implemented at all, or is implemented in such a different way that the thing that looked like it might have been effective isn't the thing that's happening anymore, right? So CI does a lot of work working with services to do that, and then we do a lot of work around trying to support high quality evaluations, which in any system, and there's a couple of colleagues in the room right now, we know how tough that is to hopefully implement all the wonderful RCTs that Peter talks about, and given the opportunity in a system that's not used to having to work with those kind of methods, it can be pretty tricky to get that to happen. So, thinking about implementation is really, when I first joined Campbell, I'm going to tell a story. I had a colleague of ours, I won't say who's published like a gazillion systematic reviews. He, who will name nameless, said to me, I didn't realize that there was this whole thing about actually doing what we're publishing. And I went, I know, it's weird, right? You spend all your time putting these things on this website, so somebody's got to do something with them. And I had the joy of trying to write a policy brief on hotspot policing. Firstly, I didn't even know what that was. Second, it works, right? Boom. But it took me ages to, and I have a PhD, I'm a prof at University of Melbourne. It took me a very long time, you might have been one of the authors, apologise ahead of time, to read that systematic review. It took me an extremely long time to work my way through it to be able to say, is it a thing or is it not a thing? What do we say? So I'm quite sympathetic to the world that wants to use evidence to make decisions in practice and policy. So more and more people that we work with in the government across here and in Singapore and a few other places we're working, they'll say to me, oh yeah, we're all in on evidence-based policy, we do it. And I'm like, so how do you, when you say that, how do you do that? Google. Did you say you're Googling? Yep. I have a team of people using Google. Awesome, please stop doing that. Because you're going to get the top article. I mean, everyone knows what. But here's the thing. The people in that system don't have access to all the databases that publish all the peer-reviewed literature, nor do they have time to swim their way through all of that literature, nor sometimes do they have time to understand what our own at Campbell Collaboration systematic reviews are actually saying, because researchers love to not answer the question, right? Even I feel a bit sick if somebody says to me, does that work? Well, maybe sometimes, but only in that spot and you can't say it. So Campbell's doing some nice work, Peter and his group and the other group we're on, where we're trying to be a little bit more upfront, write some policy papers that just sort of call it and say it, just to enable some decision making without telling you what to do. The other thing that I noticed just around the access to using evidence before I get into implementation is once people sort of discover for the first time that a randomized controlled trial is a thing, and they read about, you know, it being gold class and all that sort of stuff, then they'll go and find one or two RCTs. And then, as Peter was saying, suddenly we have a massive policy reform on our hands. This has happened in New South Wales very recently. Some people who were seconded to a particular place went and looked for some studies to help make some policy decisions, found a couple, weren't necessarily trained in assessing the quality of those RCTs, and voila, we have a massive reform being rolled out here in children and family services based on 2 very average randomised controlled trials done somewhere else. When there was a systematic review available that would have said, don't do it. So a few of us have had some moments in our careers that are a bit like, okay. So what I'm loving in the evidence revolution is as groups that are here and groups that are trying to sort of make information free and available to policymakers like Campbell, people are getting into it. You know, so we're on a little bit of a roll, I think, in understanding how better to access what we've got. We're also on a roll of hopefully understanding people to go to that can give the system some high quality information on evidence. So I enjoy no end talking to the for-profit consultancies, no end, going, could you please stop doing those literature reviews? You know how you guys write those policy papers for government, you use Google or whatever you have at hand, and then you say to the minister, here's a thing, and you're very convincing, and that thing off it goes? So we just collectively decide we're not going to do that anymore. So I'm good if the for-profits want to invest in all the databases and people that can access them and do it. That would be awesome. It gives us a better quality of information, so we're not wasting people's time. Finally, and child protection I'm more familiar with than I am with the sector you're working in, but the media. So I met an ex-chief of staff of an opposition leader for the federal government a couple of years ago. And I said to him very quickly, just so we're clear, scared straight makes it worse. Have we got that one? We've got it? Oh yeah, it may, but it's compelling. The minister loves it. I was like, right. Nigel Scullion up in the NT, he still loves it. He still, no matter how many times we spam his email, I walk up to him in Darwin and go, oh, by the way, you know, it's going to make them work. Oh, you're going to still fund it, right? We have to do a better job at coming up with some good, neat packages that actually work to overcome the simplicity and attractiveness of strategies like that do more harm. In child protection, we are up against it all the time. The stuff that we want to say to the minister about domestic violence, it is not welcome. It's complicated and it goes against some current very strong feelings around what drives domestic violence and gender conversations that in fact isn't being bared out in the literature at all. So after I said that fun stuff, let's just talk about this. So just to move us into implementation briefly, this is out of a article around child deaths, but it's applicable everywhere. The main challenge today is to transfer what we already know into action, deliver the interventions we have at hand for those who need them. It is such a no-brainer that could be a better choice to try and implement what we know has shown to work rather than to continually come up with new things, test them, and sometimes, most of the time, not even test them very well, and recreate the wheel. There are things, we try and say to the system, they're quick wins. They're quick wins. If we could get these in and implemented well, let's try that. Then let's use good sort of systematic discovery research to really test the things we don't. In child protection and family services, we have a major problem of remaking the wheel. We also, in Australia, and I wonder if this is the same for this sector, we have a major problem of people, now I live here, even though my accent sounds weird, and I've been here forever and I've got 2 sons, and look, I'm legit, right? However, that boat from New York, it's killing us. So someone will come down, they've got a different accent, you were fine. Then they'll sell this thing, and suddenly in Australia, the thing's gonna happen. Right? And the thing's going to happen often by spending money from elsewhere. We also sometimes do it with the UK, but luckily with the UK, the claims seem to be less dramatic than the Americans. I think it's a cultural thing. So at the moment, we're really trying to work on finding out what works, implementing and trying testing it here. Because that transportability of things cross context, the evidence just isn't there for it. That the claims of something made here will have the same magic result here. Doesn't mean we shouldn't try, just means we should do some careful adaptation. Because in the end of the day, we can have all the science, and Campbell, we can publish 1 million reviews, and we can go to our conferences, and we can have this very nice life. But people can't benefit from the things that they don't get in the first place. And health has taught us this. People cannot be cured or prevented from getting polio unless they get the vaccine. Health has done a pretty good job moving things across contexts to get them implemented. This sector, child protection, family services, we need to do a much better job doing that. And I'll prove to you why. This is a funny little thing to do. Oh, that's in the wrong order, but I just want to say that. I just wrote that while Peter was talking, just to kind of bring the drama into the room. Peter, less than $1 out of every $100 of government spending is backed by even the most basic evidence that it's being spent wisely. Thus, thinking about the use of reviews, but regardless, effective interventions and services plus effective implementation will get to outcomes. Implementation is the thing that is very rarely attended to. However, the thing that can bridge the gap, right? And it's something that needs to be focused on. It's been shown that it needs to be funded. And this is from a colleague of mine and Peter's, Mark Lipsey, who, this is all available. This is something you can get with Google, actually, this report. So he did a big study of studies, basically, meta-analysis, systematic reviews of everything around diverging kids in the juvenile justice system. Let me read this. In some analyses, the quality with which the intervention is implemented has been as strongly related to, it took me forever to be able to say this word, recidivism. I have to spit it out of my mouth. You know how everyone has that word? That word, somebody have to skip it and go, the R word, effects as the type of program, so much so that a well-implemented intervention of a less efficacious type can outperform a more effective one that is poorly implemented. Mark basically found you take an average intervention and implement it well, it does better in terms of outcomes than a really strongly well-supported intervention poorly implemented. That makes such obvious sense, right? Such obvious sense. So attending to implementation has been shown in other very high quality studies that you get 2 to 3 times stronger effect than if you don't attend to implementation. So you get more bang for your buck. This is going to be hideous, but only because I feel tired, but there's a point. I love this, just not at this very moment. So here's the, people think implementation is training. Everybody says to me, oh yeah, we're implementing, we got some training in and we're good, we're doing it now. You know the saddest thing for the registered training organization industry? There's been so many studies, even systematic reviews, that show training in and of itself is the most ineffective thing to do for implementation. Oops. It helps people know something better, but it doesn't help people or a system do anything differently. So our attempts to implement, say, hotspot policing might focus right on the front line of the people that are meant to be doing it. But if we don't change the structures behind them to enable that change to happen, they're just going to do the exactly same thing they were going to do before because the whole system is built to get them to do that. Our out-of-home care system in New South Wales, Victoria, in fact all our states and territories, is the same. We keep trying to get the front line to do something different through sending them to all sorts of magical training. Then they go back to their jobs and all they're enabled to do is the exact same thing. So when we think about implementation, and this is what is a tough message for both government and non-government because it goes beyond funding training. It is purposeful in terms of its focus on the actual thing. So the thing being implemented needs to be described enough in a way to actually be implemented. In child protection, there is an enormous amount of extremely vague interventions. We tend to like principles. assertive outreach, child-focused, culturally competent, got more for you. There was something else that came up the other day. Individual, flexible, assessment-based, and that's pretty much what practitioners get, if they're lucky. So me as a frontline practitioner, particularly if somebody called me a specialist, which means I totally need to be good at my job, because somebody said, hey, you're now a specialist, da-da-da-da-da. I could interpret that in any which way. And frankly, I then have to wing it. So interventions need to be well described with components that people can understand so they know what to do. That is a lot of work that our system right across areas doesn't do. In terms of that, it needs to be clear on its outcomes. But then the practice setting, the setting around the staff need to be addressed. So we're talking business models, training, supervision, information systems, and then there's the whole system outside the agency. So for example, there's an initiative in New South Wales called Brighter Futures and Children and Family Services, been going forever. It has tons of money. The requirements to do it are basically hour counts, right? So just you have to see families for a certain amount of visits and hours. These guys can do anything. So literally, you could be a worker going into a home, working with pretty tricky cases, and you're winging it under that policy directive. So to the New South Wales system's credit, at the moment they're trying to infuse that sort of big idea with more evidence-informed approaches. But what the tricky thing now is the way that that policy is written needs to be changed to be able to take the service on. Can you imagine how many sign-offs that takes? It's forever, right? The other thing, and the only thing that this is worth putting up, is what we try to say is, this is a whole sort of, we could go for hours on implementation science, but there's a whole system that you can wrap around an approach that you choose to do, whether it's a policy or a practice. But that system needs to take into account current level of capacity, right? So if you're putting something in place that requires 17 million clinical social workers, and in Australia, we don't actually have a thing called a clinical social work degree. So in fact, the workforce already isn't there. But somebody's chosen to do the intervention. The current capacity hasn't been taken into account. So you're taking that into account. But you're also, the arrows in the circle is trying to represent, there are a number of things that need to be done to wrap around that approach to enable it to be effectively implemented. And it's beyond manuals, tip sheets, and training. It's using data in a way that can evidence, are you reaching who you said you would? Are you implementing in a way that you thought you would? And are you achieving those outcomes? And if not, how could you continuously improve it? The thing that's fun, and one of the things that's known most in implementation science, is no matter what, it goes in phases. No matter what I think there's something like 86 different implementation frameworks published in the literature now. That's how you get famous in implementation science right now, publish a framework. Please don't, actually. We've got enough. But what's quite common about all of them is when you study the process of implementation, it happens in phases. There's always a point where someone's making a decision to do something. There's always a point where somebody needs to do some planning. Then there's that early implementation area where generally people have to do something different and no one's loving it. No one's loving it, everyone's hating it, everyone has to stick to it, and then you're going to full implementation. This is a very useful conversation to have within government and non-government, because most of the initiatives we're involved with the government go from idea to happening in 2 months. There is no evidence anywhere that that ever is possible. So everybody can say they're doing it, but when you go and look under the hood to see if it's actually happening. So what we try and do is help people understand the characteristics of the different phases of implementation and see implementation as starting from when you're making a choice, not necessarily when the training shows up. Ocean of evidence around that. This is my last slide. The only reason I put this up is because you can't read it. So that's an important point. It's best that you don't read it. No, people find this, we call it, the magic triangle. The reason that this goes up sometimes is, the point is, These competency drivers here for the workforce, most people pay attention to what do we have to do with our workforce to have something different happen, but very few pay attention to what's happening within the organisation. And leadership, and the kind of leadership that has been shown, is vital. We say if you lose leadership, the little arrow drops and the whole triangle falls on itself and everyone's just done. So people rarely remember that the data you use, your systems within your agency, the issues with stakeholders outside your agency all have an effect on implementation and all have to be attended to. And everybody's got projects of work that you could say, yep, that's 100% right now that I'm thinking about it. In addition to enabling good, effective workforce strategies to help people actually do the thing that you're asking them to do. That's it.